Hello, I'm Natalia Angelini.
I'm Sydney Osmar.
Welcome to Holland Estates. You are watching and listening to episode number 570. And today we're going to be talking about a case. It's not so recent, but it did sort of pique our interest because one of our colleagues, Stuart Clark, actually recently blogged on it. And it did pique our interest since it's a case that, it's relevant to any estate practitioner who's drafting wills on a regular basis. And it was a good sort of reminder to us as to what to keep in mind when that will ultimately gets challenged.
Yeah, so as covered in Stuart's blog, which you can find on our website, this case looks at the instance when whether or not a drafting solicitor can represent the estate when the will has been challenged, and whether or not the drafting solicitor would be placed into a conflict in doing so.
Right, and we often see that a drafting solicitor represents the estate when there is no will challenge, and it's more commonly at administration. So that's obviously uncontroversial, but it's potentially much more controversial when you do have a will challenge.
Yeah, and in particular, under Rule 3.4-1 of the Law Society's Rules of Professional Conduct, which holds that the lawyer can't act in a conflict of interest with their clients, this case looks at that rule and whether or not this instance would actually put the lawyer into that type of conflict.
Right. So maybe we can take a look at the facts, and we'll go through the facts a little bit and see what happened.
So the case in particular is Dale and Prentice. It's a decision of the Ontario Superior Court of Justice. The challenger of the will brought a motion to seek to remove the drafting solicitor as the lawyer of record. In this case, the deceased died at 95, and she was survived by 3 natural children and 1 adopted children. In January 2010, she had drafted a will that left the home to her adopted daughter, and then the residue of the estate was divided equally between the 4 children. In November 2013, she then drafted another will where she didn't leave the home to her adopted daughter and instead just simply divided the residue equally between her 4 children.
And it was interesting because the capacity of the testator was put into issue, and there was conflicting evidence in terms of whether or not she had capacity. So there was some evidence on both sides of that argument, which the court did consider. But in the end, I think the judge quite rightly saw it that this issue is what the court is going to have to consider and wrestle with. And so going to be relevant whether or not this lawyer should be, this lawyer may be a witness. So, that's really when you get down to the heart of it. The lawyer's going to potentially be a witness. So the court then looked at, is it appropriate to remove this lawyer as counsel of record?
And in addition to the possibility of the lawyer being called as a witness, the lawyer's file could also be introduced as evidence. And in this case, there was 2 employees of the lawyer who had actually drafted, sworn affidavits saying that the deceased had capacity when she executed the will in November 2013. And in this instance, the judge looked at how closely the lawyer had been working with those 2 employees and found that there was an even higher chance of the lawyer coming into conflict.
Right. And so the court did cite the case of Essa Township and Gurgis. It's a 1993 case where the court looked at, when should counsel be removed, and it really is supposed to be in the rarest of cases, and a bevy of factors were cited in terms of assessing that question, including looking at the stage of proceedings, the likelihood that the witness will be called, the significance of the evidence to be led, so on and so forth. So in this proceeding, it was at the early stages, but there had been some exchange of disclosure, I believe.
That's right.
And so in assessing the issue, the judge did land on the decision that the lawyer did have to be removed.
That's right. The judge actually stated that counsel's ability to objectively and independently assess the evidence would necessarily be affected by his interest in having the firm's legal services found to have been properly provided.
Right. There's an inherent conflict there. So no, I guess, real surprises in terms of the judge's analysis. Did you have any other thoughts in terms of any of the judge's comments?
Well, I thought it might be interesting to note there is jurisprudence that would support that when a drafting solicitor is met with conflicting evidence on a testator's capacity, that they're better to not play God and to actually draft the will while making comprehensive notes on their observations and the questions asked.
Right, and one of the reasons that is encouraged, or that we're supposed to be doing that, is number one, you're, I guess, preserving the testator's wishes as far as you know what they are, and you're really readying yourself to testify to the issue should it be raised later on, right? You already know there's possibly going, I mean, when you have a client whose capacity you doubt, but you go ahead and do the will in any event, you're sort of tweaking to the fact that, well, hey, I may be a witness in the future, and let me carefully document to make sure that I can accurately, testify to the best of my ability, and just be as accurate as possible in terms of the instructions and the rationale for those instructions and all of the probing questions that we are supposed to be asking our clients, especially when we've got capacity concerns or concerns of undue influence.
Exactly.
Yeah.
And I guess to bring it full circle then, and this case confirms that in those instances when that happens, there's a strong possibility that you might come into a conflict of interest and won't be able to act as the lawyer of record.
So I guess unless you have any other comments, this is a bit of a quick pod, because it is Sydney's first podcast, so well done, Sydney. So this concludes our podcast. Until next time, we do want to thank you for listening and for watching. I am Natalia Angelini.
And I'm Sydney Osmar.
Should you have any questions, please email us at webmaster@hullandhull.com or leave a comment on our blog. Thank you.
Thank you.